on 2024, Lordship, I made a demand justice, and that demand justice has not been considered. The coordinate bench has been directed the respondent authority to consider and dispose of the said demand justice by passing a reasoned order, Lordship. That reasoned order is not in favor of the petitioner, Lordship. Again, we have challenged, Lordship. Lordship will find
passed by the learned single judge in WPA 1439 of 2025 has been impugned in the instant appeal. The appellant seeks appointment on compassionate ground. Her mother expired in harness on 20th October 2007.
20th November, Lordship.
Where is the death certificate?
Lord, page 41 of the stay application, Lordship.
November. She applied for compassionate appointment on 7th January 2008. Yeah. Petitioner made application. In favor, the appellant is the married daughter of the deceased employee. She issued no objection certificate for providing appointment to her brothers. The brothers expired on 31st July 2017 and 22nd December 2021. The petitioner thereafter applied afresh on 24th May 2024 seeking compassionate appointment. The learned single judge held that compassionate appointment is intended to provide immediate financial assistance to the family of the deceased employee who suffers sudden financial crisis due to the death of the sole breadwinner. Paragraph. Learned advocate representing the appellant submits that as there was none left in the family, accordingly, she applied for being appointed on compassionate ground. Paragraph. The law relating to appointment on compassionate ground is very well settled. Compassionate appointment cannot be sought as a matter of right. The same is considered only to tide over the immediate financial crisis faced on the death of the breadwinner. In the instant case, the employee expired in 2007. Application made by the petitioner appellant in the year 2024 cannot be considered on compassionate ground as there is no scope for showing compassion to a candidate after such a long delay. Had the petitioner really been in financial crisis, then the application made by her on 7th January 2008 ought to have been proceeded with. The appellant did not proceed with the said application. On the contrary, she gave no objection for providing employment in favor of her brothers, who also expired subsequently. The same implies that the appellant was never in any financial crisis requiring employment to be given to her. After her brothers expired on 31st in 2017 and 2021, the appellant applied afresh in May 2024. This court is of the opinion that the learned single judge rightly dismissed the writ petition as there is no scope for showing compassion at such a delayed point of time. Appeal fails and is hereby dismissed.
My lord, can 2 is section 5, can 3 is restoration.
Restoration?
Yes. N3 is restoration, my lord.
Restoration has already been allowed, blood.
Of the,
Restoration
it was allowed,
is-
sorry.
It is allowed on 9th June, passed by His Lordship Honorable Justice Subhasachi Bhattacharya, Lordship.
Okay.
Can do a can check to দেখে নেবে ডিলেটা আছে
and one to
delay is
allow
there
Delay was, I think, kept pending.
একটু দেখে শুধু ডিলেটা অ্যালাউ হবে rest is dismissed.
Grateful.
It's not a matter of
The 17 and 18 million, on the earlier occasion, your lordship directed to
One list
serve it
চলে
afresh on the
গেছে।
state.
লিস্টটা ওখানে চলে গেছে রেকর্ডে চলে গেছে এর আগেটা
yes
But 17 and 18, your lordship had desired that we should serve it again on the state because state submission was Millard that they haven't received the copy. Millard, we could not complete the service, Millard. It's quite Millard voluminous. Millard, can we have Millard couple of days more to serve and come back?
it's up to you if you do not want to press the appeal.
No, Millard,
But they don't-
state was supposed to come up with a report.
Without the cause papers.
Millard, on the earlier occasions.
My lord, kindly see the impugned order and the orders passed in this case, my lord. Why the report was called for was for other purpose, my lord. Going,
You are representing the
I am the
state.
writ petitioner, my lord.
Oh, you are the writ
My
petitioner.
lord,
yes?
they have no locus. We are challenging the.
Where is the state? Mr. Kunalji Bhattacharya and Miss Rajini Singh Dev.
He appeared.
I see your name recorded.
Copy খুঁজে পেয়েছো তোমার অফিসে?
কপিটা দাও না, কপি তাহলে পাইনি possibly. এই যে কপিগুলো দিও।
Appeal arising out of which order?
My lord, kindly
Millard,
takes the order, my lord.
There is a leave to appeal which is also.
Oh, there's a leave to appeal
Yes,
My
allowed.
lord,
Yes.
No, my
No,
lord,
it
we
has
are
not been allowed.
challenging their locus
No,
to
Millard,
file an appeal,
let
my
me,
lord,
Millard,
because the
first-
impugned order has
let-
not been
let
passed
me,
with
Millard,
respect
place
to
the
the
case.
appellants.
Let me first place the case. The persons who are seeking Millard to prefer this appeal, they had preferred a CAN application for addition of parties before the honorable single judge.
Hmm.
Without disposing that application, Millard, the final order has been passed. Now, from the facts, Millard would find that the entire allegation was slapped upon us. In the writ petition,
Allegation of?
Millard, certain fabrication and forgery of record of rights in the office of the BLLR. That is the allegation. Now, Millard, where we have not heard is, why we say we are agreed by the order is, Millard, originally the learned single judge had passed an order constituting an SIT to conduct an investigation. That team, led by the superintendent of police, had investigated, submitted a charge sheet against me. After that, suppressing that order, Millard, the final order has again been obtained, seeking a further investigation by the Inspector General. We say, Millard, this is a classic case of double jeopardy, where in respect of the same allegation, Millard suppressing the earlier order and
Who constituted the SIT?
the court
Court constituted?
by the honorable single judge.
Where is that order?
My lord, this is a
Millard-
misleading statement, my
Wait.
lord.
Millard, let
My lord,
me
kindly read the impugned order once, my lord.
Then, state, there is a submission that SIT was
Oh,
conducted.
Millard, I am sorry, your
Yes.
lordship has probably heard this matter. That
My lord,
SIT
not the final
the
order. my
first
lord.
SIT was.
My lord, may I place
constituted
the
by
case,
your
my lord?
lordship.
They were never in the proceeding, my lord. What they are submitting is completely false for what they have placed in records in affidavits, my lord.
Millard, I put a very simple question to myself, Millard.
Now the submission is just, it was constituted by this bench.
My lord,
Millard,
what has,
Mr.
That be so.
Mr.
my lord, there
Paul
was no SIT constituted, my lord.
Mr. Paul
My lord,
was
what was
for the
happened
state,
was
he
earlier
reminded.
an inquiry team,
Whatever. So
inquiry committee was.
Was any of the members
My lord,
of?
my lord has committed, passed an order to constitute an inquiry committee, my lord.
My lord, kindly, সবাই আমাকে একটা
But subsequently, the inquiry report revealed alarming facts. That's why SIT was formed, my lord.
পাচ্ছি না। যদি আমি একটা double আমি আমার নামটা দিয়ে দিতে পারবো।
The copy of the court's papers are yet to be served upon the learned advocate representing the state respondents. Stop. Let the same be served forthwith. Stop. Released in the next circuit. Parties shall come prepared for hearing.
Grateful, my lord.
17 and 18 both.
Yes, ma'am.
17, 18 both.
Lordship, I'm
No, I'm
playing for
appealing for
short
the
passover.
appeal.
I'm for the respondent.
Pursuant to your
I'm led
lordship,
by Dr. Arjun Chaudhary,
You are
Lordship.
for?
Respondents.
This is for private respondents. Madam, pursuant to your lordship's last order dated 29th of June. Now, we have served a copy upon the office of the landed government pleader. As
Yes.
nobody
Mr.
was,
Kunaljeet Bhattacharya,
My lord,
Rajni Dev Singh,
here in this matter, my lord.
he appeared madam, on the
I
earlier
asked for
occasion
the
for the
petitioner,
private.
my lord.
oh,
In
so
the-
you go out.
I am out.
But we have some,
Serve
Fresh.
whom?
Again, pursuant to your lordship,
Upon whom?
pursuant to your lordship order dated 29th upon the office of the
second July, 2 copies of paper.
Who's appearing for the state, please inquire.
Yes, my lord.
Just keep somebody here for the state.
এই যে, notice.
My lord, she is also in parallel.
Please collect a copy from the office because it has been
It has been
prepared.
served.
It has been served also. Collect a copy, please.
Yes,
Lordship. What is the matter about?
The matter is regarding my lord, order under West Bengal State Highway Act. My lord, the petition, appellant before your lordship, his house is just on the side of the state highway. There was some encroachment by the private respondents. One of the petitioner made a representation on 26th of February 2024. No action was taken. Petitioner filed a petition before the honorable court. That 606 of 2024, that was disposed of by an order that at the time of disposal of that matter, the state come with a plea, a report of 5th July that encroachment has been removed. But the honorable court was the fact remains at a relevant point of time, it is on the culvert on the drain. So for the cleaning of drain, culverts were removed. Accordingly, their structure were removed. But as and when the culvert was set on the drain, they again encroached. The order was on the earlier occasion, dated 9 April 2024, that if there is still encroachment, they shall take steps in accordance with law directly. So the fact regarding enforcement has been admitted by the private respondent also. The fact of enforcement is certified by the report of the state. Now, what they are done after this order, the private respondent filed a representation for permission under section 8(1) of the Act, State Highway Act. Plus the section 8 is prevention of use or enforcement without permission, but permission is granted only for the temporary purpose. The petition, the private respondents' fact is that they are continuing there for 40 years. So, just to frustrate the order dated 9th April, they have made a representation on 30th April. But though there was a specific order of honorable coordinate bench, the subsequent bench has passed the order to consider his representation. But the appeal was when heard first time, this stay was granted, and by the order, it was made clear that on which issues the appeal should be heard. That is that page starts from page 196. Your lordship, kindly allow me to place that order. But the relevant portion. Page 196.
What is the error with the impugned judgment? that-
Error is that the Honorable Court
Ah,
passed an order contradicting the earlier order passed by the Honorable Coordinate Bench, number one. Number two, the Honorable Court failed to appreciate the scope of the act. Under the act, if there is encroachment under section 10, they will issue order for encroachment within certain time. If there is failure by the parties, then they will encroach. Now, my lord, the report was submitted by the state that there is encroachment, it has been removed. But my lord,
it has been further encroached.
yes,
Yes, and they have sought for even permit to be given.
that permission is not permissible. Lordship, may I place my lord, the order?
It is not permissible. The
Yes.
court did not direct to issue permit. Court
No.
only directed for consideration and to give reasons as to why it cannot be given.
Because my lord,
Let them
the
take a decision.
my lord, representation, my lord, is for something. My lord, they are claiming for permanent permit.
That
Which is,
will not be allowed.
my lord,
Why?
which is not permissible under law. May I place the my lord, section 8?
It is not permissible.
No.
They will dismiss it. They will, how
Lordship,
are you?
kindly allow me to place the order of the Honorable Division Bench at the time of my lord, hearing the stay petition. Lordship, kindly allow. At page
Where is
1.
your counsel?
Lordship, I'm led by Dr. Arjun Chaudhary. He is in virtual mode before the principal bench, Lordship. Matter is going on, Lordship.
That will
For short pass.
incorporate something in the statute, subject to Lordship's calculation.
Pass over in the matter.
Lordship.
Mr. Commissioner is in that.
Come prepared tomorrow.
Lordship.
But tomorrow your Lordship will permit me to one time.
Yes, yes. Everybody is being permitted online.
On last occasion, for technical fault, I could not do it.
That is different. Technical, we do not have a control, but then we are permitting everybody.
Lordship.
Not today. এই নোটিশটা ফেরত দিয়ে দিন ওনাদেরকে, নোটিশ কিছু রাখবো না আমরা।
Oh, not today.
Item number, my lords, am I audible?
20 na?
My lords, am I audible?
20 kyo?
Yes,
My lord, I am appearing for the
Item
appellant in this
20.
matter, my lord. Previously, it was pointed out by your lordship, there is a delay of 101 days. My lord, the delay
photo.
application is ready, today it will be filed. Lord,
Item
today
20
it is
mana
going to
time
be
for the
filed, my
state.
lord. Kindly gives me an adjournment and fixes it on day after tomorrow, my lord.
Stay.
20.
Item number 20, my lord.
you did not file the section 5 application.
My lord, we have
No, my
not
lord,
served,
today it
we
is
will
going
not
to
serve
be
with you.
filed
Not
today.
filed.
Today itself
Not
is going to be
filed.
filed. Not
Service
filed, I am
doesn't
seeking for
arise.
adjournment of 1 day.
Actually, my lord,
Tomorrow kindly
this
fix
has
it.
become more or less by standard submission now that we have not been served. But Kuchbihar municipality is also there. My lord. They are the possibly the main answering respondent here.
Yes, Kuchbihar municipality.
And I am representing the state, my lord.
Did you serve the municipality?
Yes, my lord, we have served. The condonation delay will be filed today and it will be also be served, my lord. That's why I'm praying for adjournment, my lord.
Municipality.
The-
Who
the
appeared for
main
the
applica-
municipality in the?
Yes, my lord, it has been served, my lord.
Actually, the appeal has been filed out of time. Stuff. Application. No application has yet been filed seeking condonation of delay. Stuff. The appellant is directed to take necessary steps in the matter. Positively by day after tomorrow. List
Yes,
on
yes,
Friday
ma'am.
has to be mentioned. Let notice be served
Obliged,
upon the non-appearing respondents.
Grateful, my lord.
Grateful, my lord.
Then we will dismiss it on Friday. If it is, it doesn't, if it has not been filed, we'll not allow and we'll dismiss the appeal. Continuously taking time.
Within 20.
Around 21.
21, I'm for the appellants, my lord. What it appears from the tracking report that the articles have reached the destination but yet to be delivered. My lord. If you can, he takes it up day after tomorrow so that I come with the proper delivery report.
Affidavit of service is not ready. The list day after tomorrow.
Grateful.
I don't know how to.
Lordship, I am for the appellant, Lordship. Paper book is ready, Lordship. I am handing over serving the copy to the respondent. And kindly, Lordship, fix this matter on Friday, Lordship. Mr. Kushal Chatterjee appeared in this matter. Already, Lordship, fix the matter on Friday, Lordship. On another civil appeal. Kindly, Lordship, both are.
Hearing on Friday.
Very short matter, Lordship.
Short or long, Friday hearing matters.
So, Lordship, Lordship, this is a divorce case filed by the husband, who is the respondent. Subsequently, appellant herein filed an application under section 36 for alimony pending delay. That application not been considered, neither disposed of. Subsequently, ex parte judgment and decree has been passed by the trial court. And now I came from appeal.
What happened to the divorce application?
Decreed, Lordship.
Hello.
Decreed ex parte.
It's been decreed.
No, my lord, on repeated
Without
occasions, if
considering-
someone, on repeated
Everything-
occasions, if someone doesn't appear before the court cannot wait, my lord, indefinitely to hear the
Every
pendent
occasion is
delay
in this
application and
court,
keep the matter
paper book,
pending.
Lordship.
That is the
Paper
precisely.
Every occasion, how many occasions time was given?
Yes, my lord, I'll show. My lord, kindly takes the order sheets which are annexed at my lord page 31 to 45.
In the paper book, Lordship.
What is the interim order that was granted?
The year was
Remarriage.
stay,
Stay.
Lordship. The operation of the decree has been stayed, Lordship.
Is the respondent trying to marry or what?
But he is, my lord, according to my instruction, my lord,
Yes,
prior
married
to
already.
that order, he has already married.
Prior to order.
The
Lordship,
stay order.
during pendence, Lordship, during pendency of this appeal, Lordship, after filing this appeal,
And the
Custody for 100 days. I have surrendered and I have in custody since 65 days. Charge sheet has been filed. Now, my lord, there is a political animosity between two political groups. We are the member of the then ruler, nowadays opposition. Now, my lord, out of 19 witnesses, 11 are on bail. Charge sheet has been filed. So, for the purpose of custodial interrogation, my detention may not be necessary. And this is the first time we are approaching before your lord.
So only how many accused were granted bail?
10.
10,
10 and plus 1, 11.
11 out of 19.
Out of 9. Out of 9, all are standing on a similar footing, my lord. 10 was enlarged on bail by the Honorable Court. 1, being a female, was enlarged on bail by the Honorable Trial Court. And in item number 12, one person is approaching bail before your lords.
what do you do, Pradhan?
I am a farmer.
Only farmer or a Pradhan of a Gram Panchayat? or-
No, I have no political.
You are there in political animosity, you say?
My lord, charge sheet says.
Huh?
Charge sheet says. I
My
am
lord,
not,
I'm facing the case diary, my lord.
Ah,
My lord, medical report, my lord, I have
The medical report 107 from the charge sheet itself,
he is not involved.
is not involved in the
my
assault.
lord, there was a political rivalry, right? He
Mhm.
said, but my lord, there are materials in the case diary, my lord.
My lord, already
My lord-
10 persons got the privilege of bail, my lord. That matter may be looked in.
And now, I'm-
10
What-
persons.
Which page you are referring?
my lord, page number 91.
Observing that point, my lord, Honorable
From-
Court was pleased to grant 10 persons on bail.
From page number 66 also medical report, my lord.
No, there may be a assault by someone else, but he is not there.
My lord, I am leaving it to my lord.
no, but show the,
But show is there any
materials you have to
materials
show.
against him?
What are the materials?
My lord,
Against
then,
him?
my lord, one day accommodation, then I am
No, this way, how you are
Well,
asking
only
Well,
for?
one.
since
my
long
You
they are,
should go
that
at
is pending due to their paying for accommodation, my lord.
because my lord,
10 persons already on bail by the Honorable Court. There is no overt act against this person. Even in the charge sheet, my lord, I was saying he was not at the section 109, that is, TRS 7 is not applicable against him. Omnibus allegation against all the persons, my lord. They are on bail.
The learned counsel appearing on behalf of the appellant submits the present appellant is innocent and he has been falsely implicated due to political rivalry. And he is in custody for
65 days.
65 days. The learned counsel further submit that other co-accused persons, 11 co-accused persons
11
have been granted bail, one by the trial court and another
10 by the
10
Honorable.
by the Honorable High Court. The present appellant is also on the same footing.
My lord.
He prays for bail in any conditions. On the other hand, learned counsel appearing on behalf of the state while opposing the prayer for bail submits there are injuries suffered by the victim and he was very much involved in the crime. She also drawn attention to the court with regard to the injury report. We have considered that we have heard the submission of the both respective parties. We have heard the learned counsel for the respective parties and considered the material on record, including the charge sheet and injury report. From the charge sheet, it apparently appears that the present petitioner was not assaulted anyone and not assaulted anyone. Furthermore, there were 90 accused persons. Out of those 19 accused persons, 11 has already been granted. Considering the above facts and circumstances, we are inclined to allow his prayer for bail, since there is no any purpose of keeping him custody for any custodial crime. He may be enlarged on bail. What was the condition?
My lord, I cannot enter in the jurisdiction of the past. It was
Similar condition imposed by the single bench.
yes,
My lord,
yes.
same condition.
Same.
However, PS will be substituted, my lord, Nagaragata PS. Subsequently, that has been corrected.
What are you doing?
Nagaragata PS.
We will
I should not enter in the
enter
jurisdiction of
into the-
Nagaragata PS.
Until further. We ate at the case number 10,000 to securities.
Grateful. Item number 14, and there are 8 petitions.
1 minute, pages 18 and 19, the bracketed portion, the conditions are there.
Page number 14, item number 14, Lord, there are 8 petitions.
Same case,
Same.
Same case.
same order?
My lord,
Whether there is any allegation against them regarding assault,
no, my
307.
So for the charge sheet is concerned, allegation is omnibus.
Allegations against all the accused persons.
Same.
Same. Grateful.
Odd zone, no. So why 19 is not coming after calculation? 11 was allowed. 1 we have allowed, 12,
Holding the order
and
sheet
now 8.
One extra.
Whether he was not in FIR.
No, my lord.
So 20 accused persons are
One,
there.
how
My
come
lord,
one
then I have to
extra?
check it, my lord.
Please call him, huh?
Call the other
Please
person.
call.
Call the learned counsel, please. How many are there? 8?
19. As per the charge sheet, 19 accused
How can
persons were there.
8 come over here? One. The 7 are over here. 7 জন আছে এখানে।
তাহলে পেয়ে যাবে।
7 রেখে 8 আর ওদিকে 11 19 জন।
Seven petitioners are there. No, 8.
Not 8, 7 petitions.
7 are there.
Same order.
My lord,
One
I have
minute.
done behalf of the state.
There are only 7 accused persons here in this present application.
In total, 19,
19.
11 are on bail, in 1 in 12,
And this is
7 in 40.
It was mentioned 8, so we could not match the calculation.
I may be excused.
We had to check up and find out 7.
Maybe for traveling a lot.
Item 13? Yes, 13.
But allegation under section 1 376, 201 of the Union Code.
Who is other side?
I am happy.
And madam, this is the action. But this petitioner.
Earlier it was rejected. Earlier rejected.
Observation.
So what is the change circumstances now? After rejection?
16 madam. Kindly see the 16 of my application.
My lord, postmortem report, my lord, I am placing.
1 minute. Let him complete first. 19.
Page number 16, paragraph 20.
20.
Specific observation of High Court and did not comply. Till now.
How long you are in custody?
But about 2 years in custody, madam.
2 years.
And my application earlier rejected when I'm.
376. 302.
Yes, my lord.
What is your role?
My lord,
Allegations.
my lord, the allegation is this present petitioner has a love affairs with this victim girl. Yeah, he has taken this lady in Shukni River, and after that in the boat, my lord, by half nakeding her and putting poison, my lord, killed her and throttling, my lord. And very much, my lord, injury mark is there in the postmortem report, my lord. I am placing, my lord, very much it is there. My lord, kindly see.
My lord, the case is based on all the circumstantial evidence. No, I place it here, my lord. And my lord, kindly see.
My lord, injury report is the. No, bol.
Have you annexed the judgment? No, this is the rejection against the rejection of bail.
Yes.
Yes, my lord. Previously, it was rejected on 17/6/2025, page number 19.
My kindly see page 16 of my application. Paragraph 20. Alright, accordingly, here a TB2 of 2025 is dismissed with the observation that it is expected that the trial shall be concluded as expeditiously as possible positively within October 31st, 2025. But we are now July 26. Till that, trial not concluded.
How many witnesses are there?
Total 46 witnesses in the charge sheet. And Malad, as per the Malad, kindly see paragraph 70. Page 16, paragraph 70. that apart since the prosecution assures us that the trial will be over by the 3 months, we record such submission, but at the time of rejection of this application, but state's advocate or submits that the trial will complete within 3 months. Thereafter, Honorable Court had directed that the trial will be completed positively in October 31st.
What is the stage of trial now?
But till the trial not completed.
How many witnesses have been examined?
But my instruction is for
Report of trial.
The learned counsel appearing on behalf of the
no,
petitioner submits that the
no
petitioner
eyewitness
is in
there
custody
based
for
on
2 years.
circumstantial evidence, my lord. I'm in
Yes,
custody
there
about
are
2 years
46
without,
witnesses.
my lord.
So there is little possibility to complete the trial within a short spell of time.
Absolute violation of the High Court order.
Earlier, his prayer for bail was rejected, but there was a specific direction to conclude the trial as expeditiously as possible, positively within October 31st, 2025. The same has already been expired. How many witnesses has been examined?
My instruction is my lord 38 or 39.
My lord,
38.
302 cases, it takes some
38.
time, my lord.
Witnesses has
But the
already
state
For
been
of-
concluding the
state
trial, my
submission,
lord.
within 3 months. trial will
considering the
complete.
submission of the
But more
learned
than year has
counsel.
been elapsed, my lord.
Considering the submission of the learned counsel for the petitioner, let a report, status report be called for with regard to the proceeding of the trial court before this court. List this matter, report we file before the next appeal. And also specify why the trial has been delayed. And also specify the why trial has been delayed.
Why trial is delayed?
Whether
Next
पूरा time
Anik. Great to know.
My lord, may I have my lord's kind leave, my lord, to mention a matter, my lords. I tried in the morning, but your ladyship was not visible, my lord. Therefore, I could not follow, my lords. My lords, may I, my lords?
What is your mentioning?
My lord, there is a short GST matter, my lords. The urgency is that I faced with recovery, my lords. If it, my lords, I filed on 12th of May, 12th of June, my lord. It is not listed. If it can be included, and my lords can be taken up tomorrow or day after, my lords. Very short matter.
Have you seen whether any defective?
No, my lords, it is not defective, my lords. I have instructions that it is not defective.
Pass on the number, we'll see.
My lords, it is okay, my lord. My lords, obliged, my lords.
License টা
May I permit to mention? Today 103, one accused person is hearing for the Lordship, inclusion my list, my name, same co-accused Lordship, same co-accused, already 103 reaching Lordship.
Item 103.
Lordship.
What has happened?
Lordship, my petitioner lady have a child, small child, Lordship. Lordship, so in this case, so urgency, Lordship, kindly include in this list.
I'll
Just
take up the
1
matter
year.
just now. I will take it up just now.
Lordship.
Why are you mentioning?
So 103 inclusion, both are same because
Both means
both are same accused person, Lordship.
which item? 103 and?
103, Lordship.
And?
100, not list, not in the list, inclusion, Lordship. Not in the list, Lordship. My.
You want to
petitioner,
mention a matter for inclusion?
Lordship.
Then why are you referring to 103?
Same, Lordship, same case matter, same.
Same case. Give.
Madam, may I permit to mention a matter for correction, my lord?
What is the correction?
The name of the state council, my lord.
Give.
May I permit to mention, correction, satisfaction has been wrongly recorded.
What has been recorded?
Satisfaction has been recorded. Learned additional session judge Dinata, it would be my lord, additional chief judicial magistrate, second court Dinata.
To be mentioned tomorrow for correction.
Special court could be special court could be to special court. Also, in this kind of matters, subsequent POCSO and NDPS cases, if special court under NDPS Act and special court under can be. No, it is under 109. Oh, yes.
Yes.
Yes, Lordship. In this case of Lordship, I am for the petitioner, Lordship. This is an application for extension of tenure of the arbitrator, Lordship. But this application was filed by the project director, Asian Highway 48.
Opposition was.
Yes, my lord. Mr. is appearing in this matter, my lord.
I'm appearing
in
to
opposition, my lord.
Lordship would kindly take it up
Because this-
tomorrow. The application was served last evening only. I was
I
praying
have
let
filed
it
and
be
can
taken up tomorrow.
for such of the necessary party, which is now handling this project, Lordship. That is NHIDCL, Lordship.
What is, where is your application?
Page number 8 of CAN application, Lordship. CAN 1, Lordship.
Page number 8. Handing over.
Yes, Lordship.
Huh?
That's why we have filed a CAN application for substitution of the necessary party, Lordship.
May I?
We have handed over the entire.
Lordship,
project,
this
including
application
the
is
code.
not maintainable at all. The notification was made in January 26. The present AP for extension of mandate was filed in April, Your Lordship, when the notification was in existence. So the application itself has to go. Today they are coming up with a substitution application. And in fact, this AP number, we have taken a point of maintainability of AP number also.
There is
Your
an
Lordship.
opposition already filed today.
We have filed in
You can
opposition.
file a reply to the same. An opposition has been filed.
Yes, Lordship, but we cannot file, Lordship, because now we are nowhere in this matter, Lordship. This application was filed by the project director, Asian Highway 48.
Now
But
they
Lordship,
are not
kindly
there.
sees the page number 9, Lordship. Handing over by the project director, Asian Highway 48 on 2nd June 2026, Lordship.
Lordship would kindly come to
If your
page
Lordship,
7 of their application.
grants me
Page
leave
7
to
of their
add
Now, this is to be hard. Otherwise, it cannot be decided. The project director who was the petitioner is no longer there.
Your Lordship, kindly come to page 7, Your Lordship. Page 7 of the present application, IA1. The notification
Yes.
was in January 26.
Yes.
And AP number was filed in May. How can they file this application when they have no
But
locus to
handing
file
over-
this application? This is my
But
point, Your
handing
Lordship.
over process was completed
Handing
in
over
the month
doesn't
of
mean
June.
that they have the locus to file the
Thing
application.
is, how could you file the arbitration petition in May if the handing over was done prior thereto?
No, Lordship,
Handing over,
handing
Your
over
Lordship.
was on, Lordship, seize the page number 9, Lordship, once, page number 9,
It was done in June.
second
Handing
June
over in June, Your
2020.
Lordship. The notification came in January 26.
Notification
into
came.
effect.
Why? What was the reason for the delay in this from January to June? Why did
Not
it got
explained.
delayed? The handing over? Have you mentioned anything?
Not explained, Your Lordship. Not only this, they were appearing before another court in my writ petition where they have suppressed this. And they are in contempt of that order, Your Lordship. They have suppressed
Lordship,
everything.
because we are now relying on the
Please come.
second
The
June of
application is to be heard. Stop. The affidavit in opposition filed on behalf of the respondents in court today be taken on record. Did you get a copy?
Yes, Lordship.
All right. It will be open for the petitioner to file a reply to the same. Stop. List in the next circuit.
Lordship, but my, in regard of my CAN application,
Yes, it will be hard. The can will be hard. It's pending.
grateful.
Obliged, Your Lordship.
I'm available on behalf of the state. Brief is not available, Lordship.
All right, let me see. Yes.
Last occasion, interim bail was granted by this honorable court. It was extended, madam. Appealing for confirmation of interim bail. Last occasion, your lordship was pleased to ask for a compliance report, whether I comply all these conditions imposed by this honorable court or not, madam.
What was the reason for granting the interim bail to you?
License was granted bail, but I was granted bail.
36 kg of ganja.
Yes, madam. License was granted bail, madam.
Maybe, but
Madam.
then under what ground?
Madam, there is a ground non-compliance of ground of arrest for this reason. Honorable High Court was granted bail, madam.
What is the position of the trial?
Trial charge sheet submitted, madam.
See, NDPS case, why is the report not coming? And not, this is not the first time.
I was 8-7. Lordship, it is here, Lordship. 870. These are very old case diaries. Can I hand it over to the Lordship?
No, there was a requirement of a report being filed. Where is that report? Despite repeated opportunities granted to the respondent, the report has not been filed till date.
By tomorrow, I will.
It cannot be done. Release the matter in the next circuit. Stop. The interim bail, which was, it is still now, is it valid?
Yes, madam. Last.
The interim bail, which was granted on 25th of March 2026. Interim bail granted on 3rd March 2026, extended by order dated June 17, 2026. Stands further extended for 4 weeks. Stuff. List in the next available circuit. The report shall positively be placed before this court on the adjourned date.
And diploma. I don't know.
Item 3. None appears on behalf of the petitioners on repeated occasions. Dismissed but not for default. Yes, next. You are there for the state? Somebody should be there for the state. Four.
I did not phone lordship. The conducted advocate is seriously in ill lordship. Kindly make it not today, lordship.
Not today.
Yes, yes.
File legi. See, last occasion it was adjourned. I will not adjourn it. No question of any adjournment.
Lordship, not only not today, lordship.
I can pass it over. No adjournment. Otherwise, it will be dismissed today only. Pass over. Next.
Another file.
Please record your appearance. It is being dismissed.
Grateful ladies.
File.
Five.
None appears on repeated occasions.
No, my lords,
Appearance.
there is something else to it. If I can have my lordship for a moment on para 7 of the
Yes.
application. In para 7, from a bare read perusal of para 7, my lords, my lord will see. Before that, my lords, this has been stapled. This is page 5 is also important. So what happened was that a search and surveillance was conducted, and 2 accused persons were arrested: Krishna Majumdar and Subhash Sarkar. Now, the recovery, my lords, happens to be 865.98 kg of ganja.
Liggen into 865.98 kg of ganja
Now, I will have my lordship for a moment on paragraph 7.
recovered from the
Joint position.
joint possession.
Now, I can have my
From
lordship
the
for a moment.
person, vehicle, house,
Vehicle.
from the vehicle.
Now, paragraph 7.
Yes.
That your petitioner humbly submits that on 19 February 2026, principal accused of the present case, Krishna Burman, has preferred a bail application and that bail application was allowed. Therefore, on parity, this petitioner also is claiming a bail application. Now, if I can have my lordship for a moment on the bail application of Krishna Majumdar, which is annexed as at page 11.
Dismissed.
No, it was allowed. I will come to the facts.
All right.
Page 11, my lords, is the bail application that has been allowed. Thereafter,
Yes.
Thereafter, my lords, in this particular case on 25th of March 2026, it was taken up by a coordinate bench by my lordship Honorable Justice Basak, and there is an order there. In terms of that order, my lords, we have conducted an inquiry, and I can submit before this court, my lords, that in total there have been 29 such cases wherein, my lords, section 42 was complied, but it was not brought to the record of this court, and because of which bail waivers allowed. If I can have my lordship for a moment on the report. Out of these 29 cases, my lords, we are already in the process of filing bail cancellation in 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 cases. So this application may be placed along with the bail cancellation application for Krishna Majumdar, which is in the process of being filed. In all these 29 cases, my lord, section 42 was complied, but it was submitted before the court that the 42 has not been complied, and therefore bail was granted.
My lord, since long, another co-accused who have been granted bail, he have been enjoying the bail.
Steps are being taken for cancellation.
But my lord, since long, I am depriving.
Anyway,
My lord,
please take down.
my lord, kindly directed them to
KG.
as soon as possible. My lord, both the matter can be heard.
KG,
So my lord, I can be benefited.
Atto was found joint possession of the petitioner along with one Krishna Burman.
With Krishna Majumdar.
Krishna Majumdar.
Krishna Majumdar.
February.
Stop. It appears from the petitioner praised bail on the ground of parity, as the said Krishna Majumdar was granted bail by the court on 19th of February 2026 in CRM NDPS 467 of 2025 on the ground that the provisions under section 42 of the Act have not been complied with by the arresting officer. Yeah, just stop. The AAAG has brought to the notice of the court that section 42 was duly complied with by the conducting officer, but the said report was not placed before the court, for which the order for bail was passed. Steps are being taken for cancellation of the said order of bail.
The last serial number is this particular.
Departmental action is also being taken against the defaulting officers for not bringing the aforesaid fact to the knowledge of the court. Next. An entire list of 29 cases where the aforesaid non-compliance where the aforesaid compliance, where the compliance of section 42 was not brought to the notice of the court, has been placed before this bench. Paragraph. Upon perusal of the report of the Additional Director General of Police, North Bengal Region, signed on 1st July 2026, and in view of the commercial quantity of contraband recovered from the possession of the petitioner, the prayer for bail stands rejected.
I'm deplorist.
I don't know, 7.
Yes. Acha, the list that was given by Mr. Mishra, this list shall be kept here because you never know this cases, 49 cases.
Yes.
It may be required in any of these.
I have another copy of it. It is with the office of the AP.
Yes,
APP.
let the other
Yes,
APs
yes, yes, yes.
also be
Yes. Absolutely.
notified. You never
ma'am.
know.
I'm okay.
Yes, parity.
Yes, madam. Claiming parity. madam.
What is your submission?
Lordship, in this matter also same kind of submission will be there, that we have already taken time on the last occasion to file cancellation. So initially it was to be made before Supreme Court because there was no provision as such. So after there is a change of circumstances now, there is one judgment by the Honorable Supreme Court with respect to for filing of cancellation of bail can be done before the we can file it before the coordinate bench. So by next week we will be doing that. With drafting as complete, by next week we will be doing that.
What will be your submission with regard to the delay in sending the samples for testing?
Delay in sending the samples.
Because that is the ground I see for which the bail prayer was allowed.
Lordship, that can be with respect to that, bail cannot be granted on that ground.
This is what has been done. You see, this is what the parity which the petitioner seeks. Acha, please come. The petitioner seeks parity. Bail on the ground of
52A.
parity. Stop. It has been submitted that the co-accused has been granted bail by the court On
Matlab,
13th
I am in
September.
custody about 3 years, 6 months. Matlab, till today, no witness was examined. Matlab.
And 13th September 2023 in CRM NDPS 604 of 2023. Stuff. The petitioner is in custody for 3 years and 6 months. And the trial has not proceeded. Stop paragraph. Learned APP opposes the prayer for bail, and it has been submitted that steps are being taken for filing application for cancellation of bail granted in favor of the co-accused. Stop. What is the quantity that has been seized? How much?
28 bottles and 22 bottles.
Commercial quantity of cough syrup. Penicillin.
Codeine.
Recovered from the conscious possession of the petitioner. Stop paragraph. List the matter in the next circuit. Stop. Necessary instruction from the state shall be produced before this court on the urgent date. Next circuit. Next circuit. Not press.
Item 9.
I'm appearing on behalf of the state.
Yes.
Petitioner Madam was arrested on 13th of November 2025 by BSF. Recovery from him allegedly is 200 bottles of cough syrup. I would like to draw my Lord's attention to the first information report. It's at least 12 of these certified copies. Page 12 is written top right column there. Premier place assembly. I'll read the column 7 details. And one thing I'll point out, column 2, the date and time of the incident, it's 12/11/25 at 11:10 hours. Please may kindly be noted down. The brief details. I am producing herewith the apprehended accused namely Jalpaiguri, son of Abdul Bari Sheikh, resident of such and such, date of birth such and such, Indian national, along with Caesar memo attached to the complaint. The case is under. On dated 12th November 2025 at about 22:30 hours, specific information was received that some smugglers may try to smuggle contraband items to the AOR BOP Pulshahat by carrying the potla during the first shift AC2.5. Boy commander planned and led a depth ambush in one part behind the domination line in rice crop field in alignment of ACT point number 4 to 5 of BOP. Party was led by Sergeant Such along with Sergeant Such and Sergeant Such.
Listen, for consideration of the application for bail, all these things are not required to be looked into. Why?
Because of the time of arrest, my lord, and the grounds of arrest, my lord.
All this in trial.
No, ground of arrest cannot be in trial, my lord. I beg to differ on that.
Maybe.
That's the constitution, my lord, then I have to kindly place this before the next subject.
Not grounds of arrest have been communicated.
No, it's not.
Communicated.
Yes, ma'am.
My lord, that is the memo of arrest, my lord, it is relying upon. And
No, no. No, sir.
Fill in the blank format. I've seen the copies.
So let me rely on what I am relying upon.
My lord, I'm not only on ground of arrest, I was arrested on 11th, my lord. There was a re-seizure. There is no concept of re-seizure in criminal law. My lord, thereafter I am produced before the court on the 14th. My lord, if my learned friend is relying upon a fill in the blanks format of ground of arrest, that is absolutely impermissible, as per the latest judgment of the Honorable Apex Court, my lord.
On behalf of the state lordship, we also need to make one submission with regards to all these kind of pleas being taken by the defense. The issue is that these are the constitutional rights, what they are saying. Now, there are cases where videography has been done. And the seizure, everything is done under videography. So this cannot be, at max, this can be a procedural defect. Not that their right has been curtailed or their constitutional right has been curtailed.
In this case, was the videography done?
Videography done, Lordship. Yes, I'm dot. And I'm really relying on another judgment wherein it has been mentioned as procedural defect. Paragraph 20.1.17. Lordship, very vital, Lordship. In case of heinous crimes, this was a 302 case. So in case of where there is a NDPS cases, all cases are having commercial quantity. These are heinous crimes, crimes against society. So in this kind of cases, for this kind of, because the false implication can be there. So for that, the special provision of videography was done. So if videography is done, and if seizure has been made after following the procedures of videography, so how their constitutional right can be affected?
Absolutely, my lord. So, absolutely. Because
My lord, what-
has got nothing to do with videography of the entire service.
Please come.
My lord, I'll not press this application. My lord, kindly there. Because my
Hello,
lord,
after
my
then-
rights are not addressed appropriately, my lord. Violation of Article 21.
After placing the matter for such a long time,
My
now
lord,
you
such a long
say
time,
you
my
do
lord,
not
my learned friend
want
is
to.
placing my lord, kindly, my lord,
The
hear
court
me
is
out.
not looking into the judgment.
My
The
lord,
fact that
I'm covered by the judgment.
you have been that contraband has been
My lord,
seized
there is
from your
unlawful
possession.
detention. I'm on that point.
Unlawful detention will be seen at later point of time.
My lord, I'll not press the application.
Not press.
Extensive hearing and not pressing the application.
Judgment নিয়ে নেবে।
Judgment I think judgment দিয়ে দিই।
I don't know, Tim. I'm for the state lordship. Why? Which document? You have filed the petition without the document. Without document, did you file? What document you want? Tomorrow, not today.
Lordship, in this matter, a status report was called for. So can
Yes.
it be taken in the record? But
And tomorrow I'll keep it
Okay.
record and order. Adjourn for the day on the prayer of the petitioner. Record and order. I don't know, 11. Item 11. Dismissed. Record your appearance. Item not 12.
my lord,
Yes. Not press.
Jahangir Alam.
13. I don't know, 13.
Police station case number 2.
Tomorrow, on the prayer of the petitioner.
Not this.
Is anybody there in this item? Let somebody appear tomorrow. And be ready with the CD and the facts and everything.
3 জনের নাম দিয়ে দাও। দেখো আমি। এলো।
I'm instructed to not press this application.
Yes, not press.
I'm for the state lordship.
Appearance. Adjourn for the day on the prayer of the petitioner. Somebody should be there. State. Item number.
Not this.
16. Dismissed.
নাম দিয়ে দে, নাম দিয়ে দে।
And
17,
All statutory compliances made, official report is there, it is 14, second report is recovered.
dismissed. Record appearance of the,
On merits,
yes.
on merits, it will be dismissed. I have a case study with me.
I am
The
not,
memo of it is
none is
50
being,
comply,
yes,
50
your
comply.
submission will be recorded. None of the matters are dismissed for default.
আইটেম নাম্বার 12 লিখে দিয়েছি
18,
33 নম্বর না
dismissed.
309 33 নম্বর আইটেম সিআরএম 309 34
Dismissed. Yes. Very well, 21 to 24, not press.
21 to 24.
Please record appearances. Dismissed.
2025
Six.
Urgent for the day on the prayer of the petitioner. 26, state must be there.
এটা ভুল লেগেছে
My lord, the petitioner is in custody for 146 days, my lord. My lord, no recovery has been made for the petitioner, my lord. My lord, on 16th of March 2023, a person named Naresh Kanti, who is the sole accused, my lord, the recovery was made from him. My lord, at the time of arrest, he took the name of the petitioner, my lord. On the basis of that, the petitioner is taken into custody. I am in the custody from 12th of February this year. My lord, no witness has been examined, no recovery has been made from it. And my lord, one more thing, my lord, that sole accused was already released on bail, my lordship.
Sole accused released on bail.
My lordship. On, my lord, 27th of July 2024.
State.
Lordship, in case ID, page 18, the name of the present accused petitioner came.
Has the sole accused been released on bail?
না না ওটা দেয়নি তো ও আচ্ছা এটা
No recovery has been made from it.
Name of the accused. Naresh
একদিনই নিয়ে নাও
One Naresh Kamti.
I am Shelu Kanti, my lord. The sole accused was my lord Naresh Kamti, who is on bail.
কি পাওয়া গেছে এর কাছ থেকে কত
The recovery was made from him, my lord. 26 bottles of protein.
স্টেটমেন্টের উপরে ক্রিমিনাল অ্যান্টিসিডেন্ট
Lordship, one day accommodation is required for status.
My lordship is
Present status.
Acha, the petitioner is in custody for 146 days. Stuff. It has been submitted that no recovery has been made from him. Stuff. The sole accused has been granted bail by the court on 23rd July 2024 in CRM within bracket NDPS 272 of 2024. Yes. Learned advocate representing the state seeks time to revert with necessary instruction released day after tomorrow.
Deeply obliged, madam.
Noisha.
28. Dismissed. Not default. Dismissed. Petitioner is not appearing. Pradip's কাছে order আছে আপনি দেখে নেবেন।
Twenty-nine.
29. Dismissed.
Number 30 and 31 paying for short passover, my lord.
All right, pass over.
Grateful, my lord.
Dismissed. Dismissed.
Appearance.
Please record appearance.
My lord, I am appearing on behalf of the state, my lord. Commercial quantity, my lord, all the formalities have been fulfilled, my lord. FSCL report is there, my lord.
Please take down all these things. State submits. Commercial quantity of contraband seized. All statutory formalities complied with. FSL report is on record.
My lord.
Dismissed.
Alright, 35 and 36, lordship want to not press the application.
35 and 36 not press. All right, great, not pressed.
My lord, this is the change brief, my lord. We have not received the wakalatnama, my lord. Kindly make it day after tomorrow, my lord.
On the prayer of the petitioner adjourned till 9th. Give your appearance.
Dismiss.
I am on behalf of the petitioner.
Quantity,
My lord,
quantity.
The FIR is in page number 9, my lord. It is alleged the quantity is 35.790 kgs of ganja, and it is alleged in the FIR, my lord. The FIR page 10, last para of the FIR. The fact is stated, my lord. So it says that page 10, my lord.
Yes.
It states that the train was already standing at the platform number 2. I am Ashu Anuragi. There were 6 accused persons who were arrested in this. I am one 19-year-old boy, my lord. And my lord, I'm reading the FIR. The train was
Now
already.
listen, all these things cannot be looked into.
No, I am just talking about the nexus, my lord. There was no nexus of this present
All
petitioner.
at the stage of
I will
trial.
show 3 judgments, my lord.
Here only the court has to see whether the twin conditions are fulfilled for
Yes,
grant
that
of
twin
bail.
condition is that there must be a reasonable belief that the petitioner has not committed the crime.
Yes.
To show that, my lord, I
And
have to read.
to show that the state will oppose.
My-
So no use.
My lord,
If
with regards to
commercial
the
quantity.
nexus, my lord, the present petitioner had no nexus with the contravention because he was walking in the train, my lord. I have that document. He happens to be a 19-year-old boy who is walking in the train, my lord, from inside the train. Actually, from inside the train, the gaja was found. But later on, they have framed this case, stating that 6 accused persons were standing on the platform, and from their bag, 4 packets of gaja was found. 4 packets from 6 persons, not possible. They state in their FIR that it was inside their own bags. So if 4 packets of gaja cannot be found from the 6 persons, and this present petitioner, my lord, he was given the in charge of B2 coach, which is in page number 13, my lord. I have annexed his duty roster, page 13, my lord, annexed to P3. Ashu Anuragi. Now, my lord, it's point number 5.
17th of March, your earlier application stood.
But I not pressed it, my lord.
Yes.
I not pressed. Why did I do so, my lord? As because my education qualification certificates were not there, and I have annexed to that score, my lord, page number 23, my lord. Now, this is a certificate showing he's studying electrician, my lord, and he is just a student, my lord. He was present at the wrong place at the wrong time, nothing more, my lord. Nothing was seized from his possession, my lord. He was working in the train, my lord. A student of 19-year-old, my lord.
Submission?
And with regard
Ladyship,
to
it's a
3
case of-
judgments, my lord.
No, I won't see the judgment at the bail stage.
Ladyship, it's a case of conscious possession.
But
your
with regard
ladyship.
to
Case
bail
of
only.
conscious
It's a case
possession.
of conscious possession.
Strongly opposed by the
The
state.
conscious possession, my lord.
Ship,
My
all
lord,
these- all-
he is working inside the train, my lord. 19-year-old boy, my lord. His whole future will be destroyed, my lord.
Nothing
My lord,
going.
I have 3 judgments on that,
It
my
was
lord.
kept
If your lordship kindly allows me to show the judgments,
No,
my lord.
please, I won't
With
see the
regard to the
judgments.
nexus, my lord, there is no nexus
No.
with this child and the contraband, my lord.
Please
That
come.
much I am saying, my lord. On any stringent condition.
No,
my
no,
lord,
the
I'm saying.
Supreme Court is coming down heavily.
My lord, that is why the reason of belief is required to be recorded, my lord. The reason of belief, my lord, because there is no nexus of this child, of this boy with the contraband, my lord. He was walking in the train, my lord. And in the train it was found, my lord.
For how many days are you in custody?
I am in custody for 300 days, my lord.
The petitioner is in custody for 300 days. Stop. Learned advocate for the petitioner submits that he is a 19-year-old student. Stop. No amount of contraband was found from the possession of the petitioner.
My lord.
Stop. He was working in a train. From where the contraband articles were seized. Stop. The
My lord,
petitioner
he was in B
has-
coach,
he was
B2.
in
The contraband
coach.
was found in B4, my lord.
The contraband articles were found in
Coach number
B2.
B4.
B?
B4.
B4. And
And he was working in B2 coach.
He was working in coach number B2.
And all the 6 persons who were arrested are all the employees of the train, my lord. And even the police
The other
themselves have stated.
co-accused are also employees of the train.
And my lord, even
The
the
petitioner has been wrongly framed. Stop. There is absolutely no nexus of the petitioner with the offense that has been committed.
my lord, in page number 70, even the police have stated who is the principal accused in this case, my lord, and they were not even associated with the crime, my lord. Even police has stated that.
The petitioner,
Page number 17, my lord.
the petitioner is nowhere related with the crime, as will be evident from the police report, page 17.
Page 17, my lord.
Which portion?
My lord, during remand period, I thoroughly interrogated with the PC accused persons, and on there they admitted the guilt. They stated one coach attended B4, train number Deepak Rath, who is still absconding, my lord, who handed over the set seems to be Gaja with a direction to carry the said Gaja in the said train to deliver to one Siddharth Rawal of Rajasthan. And B4 coach supervisor was someone else. He is Neeraj, my lord.
Acha.
Who is also Neeraj Kumar, who has been arrested in this case.
Police report, bolla. At page 17, in the police report of the investigation officer. Report, police report na kore, report of the investigation officer. dated 26th of September 2025. Prayer has been made to grant bail to the petitioner. Stop. The aforesaid prayer of the petitioner is strongly opposed by the learned advocate representing the state. Stop. It has been submitted that the petitioner was in conscious possession of the contraband. Stop. All statutory formalities have been complied with. Stop. Paragraph. On hearing the submission made on behalf of both the parties, and in view of the fact that commercial quantity of contraband was recovered from the joint possession of all the accused, accordingly, the court is not inclined to grant bail to the petitioner.
Well, a speedy trial direction may be given, my lord. Till to date, 2 accused persons are absconding. There is no, so a speedy trial direction may be given, my lord.
The learned trial court is.
And 1 application is also pending, my lord.
Directed to take up the trial and try to conclude the same as expeditiously as possible.
I'm grateful, my
Lordship, item number 17 and 19 dismissed for default. I'm not.
No, none of the matters have been dismissed for default, all dismissed on merits.
So I'm not.
Petitioner.
pressing those objections.
Now not pressing. Acha, not pressing. Item
17 and 19.
take a note. 17 and 19. None of the matters, I make it clear, are being dismissed for default. All
I'm sorry, I was in court number
deliberately
5.
not appearing,
No,
and
sir,
that
I
is the
was-
reason dismissed.
My
Alright.
matter was going on in court
Very
number
well,
5.
17, 19, not pressed on the learned advocate.
Grateful, my lord.
Item number 39.
39, dismissed.
And 40, 41, I want to not press. sir.
Not press. আপনি একটু প্রদীপের থেকে অর্ডার গুলো দেখে নেবেন কিন্তু একটা
My lord, one.
পিটিশনার নিজে বলছে নট প্রেস আর একটা ডেলিবারেটলি আসছে না, সেই জন্য মেরিটে ডিসমিস হচ্ছে।
My lord, one interruption, my lord. Item number 39, I was in court number 5, or maybe order passed, my lord. I am praying for not press application. Item number 39.
39
39, my lord.
ওনার সাবমিশন রেকর্ড করে নট প্রেস।
I'm grateful, your lordship.
You have so many friends over here, why don't you tell somebody to seek a passover?
I made a mistake, my lord. I could have.
All right.
42.
I'm the petitioner.
Yes,
But
how
first
many
I'll-
days custody?
Custody, I'm from 28th of July,
Which year?
near about a year, last year.
Last year.
Yeah,
And
about 2 years.
commercial quantity?
Commercial, it's only, I think, 80 boxes of tramadol capsule. My lord, thing is different, my lord. I take my lord to the affair of the case first. My lord will find that 2 vehicles were intercepted, 1 4-wheeler and 1 2-wheeler, and 3 persons were arrested. Now, from where they were, who were there in the 4-wheelers, who were there in the motorcycle,
That
that
is a
is
matter
not.
of trial, you can.
First, I do
file it.
admit,
So why will the court
I
at the
do- I-
bail stage?
My lord, at the
allow
time
it?
of trial, I do admit, my lord. Now,
Then-
next is that the search and seizure. My lord would go to the search and seizure that is in the main application, page number 17, my lord. From where it was seized? From the vehicle, whether the goods, the contrabands were in the vehicle. It was in the
Page number 17.
page number 17 of my application. P5.
Yes.
My lord, it was
Seizure
seized
list.
from the, from whom seized? Place of seizure is
You are Mominul Haq.
from the possession of,
possession.
no, three accused are there, my lord.
You are
From
there
the-
also.
Yes, from the possession of Babul Islam, who is resident of Dhubri, Assam. The next is Shahadur Ali. He is also a resident of Dhubri, Assam. And I am Momirul Haq. I am a resident of Madarihat. And this is a case of Falakata PS. My lord, my case is that my petitioner was in a motorcycle. He was traveling from his house, Madarihat, to Falakata, where the vehicle 4-wheeler was intercepted with other 2 accused person. I was a passerby in the motorcycle.
I have been entangled in this case. Now, in the scissor list, nowhere it is written from whom sis, what sis. My lord, I'll just read out paragraph
No,
number
sorry,
4.
sir. Nothing can be done. Commercial quantity, nothing.
My lord,
The,
my lord, commercial quantity, but these things, my lord, the restriction of section 37, if these things are there, if this, at the
petitioner
trial
is in
also, they
custody
cannot succeed, my
from
lord. Why should
28th
I
of
be
July
behind the bar for a long
2025.
time?
Stuff. Commercial quantity of contraband was recovered from his possession. Stuff. It has been submitted that the petitioner was
My lord, one indulgence, my lord.
passing in a motorcycle and the vehicle and a four-wheeler vehicle with the contraband article was intercepted by the police. Stop. The petitioner is no way connected with the instant case. Stop. Petitioner prays for bail. Stop. Learned advocate representing the state opposes the prayer for bail. Stop. It has been submitted that the statutory compliances have been complied with. Stop. Paragraph. It appears that the prayer of the petitioner, that the petitioner did not press his application for bail. And the earlier application being CRM within bracket NDPS /94/2026 stood dismissed as not pressed on 18th March 2026. Step paragraph. It does not appear that this is a fit case for allowing the petitioner's prayer for bail. Step. The prayer stands rejected.
Grateful, my lord.
Grateful.
Number 43.
Item number 43, the conducting counsel is made with an accident, lordship. He is grievously injured, lordship.
Who?
Mr. Shrupritam Nag.
Counsel is injured,
Yeah, lordship.
hospitalized.
Now he's in bedline condition.
Yes.
If your lordship may kindly enough to fix day after tomorrow, I will submit the
All
documents.
right.
Lordship.
Adjourn till day after tomorrow, 9th.
I'm grateful,
On the
ma'am.
prayer of the petitioner.
In 44, Lordship, I am for the petition, Lordship. And the cases, Lordship, nothing has been recovered from the possession of the petitioner. Lordship, kindly come to the FIR, Lordship. This is Lordship, the page number P1, that is page number 9, Lordship. Kindly come to the last para, Lordship, that is on page number 9. At about 21:50 hours, Lordship, get it? Page number 9. This is the FIR.
Yes.
On last para, in the middle portion, I apprised the detainee in about the information of the and stated examination thoroughly on being asked, revealed her identity as Madhavi Kundu, who was arrested. This is Madhavi Kundu, Lordship. And the contraband recovered from his possession, that is been page number 20, para number 5, 20 kg 661 gram. So this has been seized from the another persons, that is been Madhavi. And from the Madhavi, mouth of the my name came, that is been when he was in custody, she was in PC, Lordship. Now, Lordship, come to the, my case charge sheet, Lordship. Charge sheet has been already been, not prior to that, Lordship, come to the page number 17. During remand period, the female PC accused, that has been PC female accused with Madhavi, accused person was thoroughly interrogated, and it has transferred that one Rajesh Sharma is close associate with the accused and he is actively involved in the supply of the such contraband. This has been come from the mouth, Lordship. So this is the my name is come out from the mouth of the co-accused, principal accused, and thereafter, after 3 months, 1.5 months, on 9th November 2025, principal this petitioner was arrested. Now, Lordship, come to page number 18. 18 is the scissor list, charge sheet, Lordship. This charge sheet does not reflect that anything has been
recovered from the possession, contraband has been possession from the present petitioner. The last part, column number 12. The 11 package wrap, this has been serial number 1 possessed from the principal accused, and from my possession, the principal accused, that is para number serial number 2 mobile phone. Nothing has been seized. He is in custody for 43 days. Lordship. Charge sheet has been already been filed. So far as the contraband is concerned, that has been seized from the another persons. So he is this petitioner is not way connected with anyone.
All right, please come.
Lordship.
The petitioner is in custody for 243 days. Stop. He is not the FIR named accused. Stop. His name came up at the time of investigation of the principal accused. Stop. It has been submitted that the petitioner is no way connected with the aforesaid incident. He may be released on bail. Stop. Learned advocate representing the state. Who's for the state? Learned APP opposes the prayer for bail. Stop.
No CD.
It appears that the sole accused disclosed the name of the petitioner and clearly indicated that he was involved in the supply of the contraband substances. Stop. The communication between the sole accused and the petitioner revealed from the CDR analysis. Stop. Paragraph. It appears that commercial quantity of contraband was recovered from the sole accused who is in custody. Stop. As the petitioner's name has been found to be actively involved, as the petitioner has been found to be actively involved in the supply of contraband substances, accordingly, the court is not inclined to allow his prayer for bail. Stop. The same stands rejected.
Lordship, they are at this stage only.
At this stage.
At this stage.
At this stage.
45.
45, 46 and 37 came from next seven.
No, next circuit
42
will-
complied, 50 complied, ground of arrest was there.
No, next circuit it
516
will not be adjourned.
516 kg of ganja.
It will not be adjourned.
Then 96 died actually.
Why? Today.
No, another contesting advocate is out of station for his mother's treatment.
Tell him to join online tomorrow. I'll make it not today maximum.
They are 96 is Thursday.
Thursday on the prayer of the petitioner. 45 and 46.
46 and 47.
45, 46 and 47. Tinte. 9th.
Okay.
Lordship, I want to not miss this application.
Not press.
Lordship, I am for the petitioner. Lordship, during the pendency of this application, charge sheet has been filed before the trial court, Lordship. That need to be placed before your Lordship,
Yeah, you thrash it out before the trial court. In trial.
Lordship, I'll collect it, Lordship, and collect day after tomorrow.
What is the use of keeping this bail application pending?
Lordship, charge sheet is important to decide the matter.
Yes, in the trial it will be important for purpose of bail, it is not important.
Yes, Lordship, there may be some grounds, Lordship. So kindly day after tomorrow, I'll take a copy.
Day after tomorrow, I'm ready. On the
Grateful.
prayer.
Item number.
Praying for not today, Your Lordship. Not today.
Not today. Why?
Actually, Your Lordship, advocates on records, sister, Your Lordship has died. So that's why he couldn't able to come.
Now this time I'll impose cost. Just now the submission was that advocate on records mother is in hospital. Now sister has died.
I have been instructed.
Yes. So what will be the next ground? I'm going to dismiss with costs.
Kindly only make it not today, Your Lordship. I've been instructed like that.
Not today on the prayer of the petitioner.
Grateful.
What is your name?
Shomujit Lashkar, Your Lordship.
Shomujit Lashkar. लिख रखिए. 51, same prayer.
My lord, with regards to my lord, item 51 to 53, my lord, the learned advocates on records are Miss Upasona Chetri and Mr. Ajoy Das. My lord, it's a transfer brief. My lord, I have received the briefs today, my lord. My lord, if the matter may be taken, my lord, day after tomorrow, I will positively do the matter, my lord.
Very well. Day after tomorrow on the prayer of the petitioner.
Grateful, my lord.
54. Mr. Anirban Banerjee, 54.
I do not press, Your Lordship. I do not press this.
Brief freshly handed over. Oh, same chamber, all right.
All the formalities have been complied.
Yes.
Regarding C0.
Not press. And next all, 55, 56, not press.
Yes, not press, Your Lordship. Only 55, Your Lordship. I have 56. Sir.
Also, 55, 56, not press. Punta? নামটা নেই আমার 52 টা I'm for the state lordship. Record your appearance. Dismissed.
57, Your Lordship, not press, Your Lordship.
It's a not press. সুমন্ত আলাদা আলাদা অর্ডার আছে একটা পিটিশনার বলে নট প্রেস একটা নট প্রেস
58 and 59 not pressed. Down.
60.
But I mean, we have a district.
Dismissed. Your appearance should be good.
Good.
61.
I can do state.
All right, I'm for the petition. I will not press.
Not press.
57, 58.
62, my lord, I am for the petitioner, my lord, praying to not press the application.
Very well.
57, 58.
63 praying for not press this application, my lord.
60?
63, not press. 63, 64 and 65, my lord.
All right, not press.
Grateful, my lord.
State's appearance should come down fast. Yes.
65 of people not press. দাদা আকবর 16 টাইম
66.
Lordship, not pressing the application.
Your appearance, please. Not press. Not press.
69.
69. My lord, in this case, the charge sheet has been filed in just 2 days back. So you have not been handed over. This is the first application I'm paying for next circuit.
What has the charge sheet got to do with bill?
Because there are many important things, but the loopholes in the, that is very much.
All in the trial.
My lord, this is
What
first,
is the ground in bail?
this is his first application, my lord. He will be
So
busy.
what?
Man, just we have not been handed over without going through it. He will be prejudiced, my lord.
Alright, day after tomorrow.
My lord.
Day after tomorrow, 69 on the prayer of the petitioner.
এটা থেকে নাম দিতে হবে।
Lordship 70, I'm not pressing the application.
70, you are not pressing.
70 নাম লিখে দাও।
দেবব্রত আমার সাথে 57 ছিল।
কততে ছিল?
Alright.
গোবিন্দ দা
70 appearance given?
Yes, Lordship, I'm giving.
Please.
Not press.
Lordship 72, I'm moving the application. I'm for the petitioner in this case, Lordship. I'm moving on the ground that there is delay in trial, Lordship. Delay in trial, he has been languishing in custody since 506 days, Lordship. Until now, Lordship, charges have not been framed. Next date is fixed for 37/26 for production of charge. Time and again, Lordship, the prosecution is taking time for framing of charge. And Lordship, there is only sole accused in this case. In the FIR, there were supposed to be 5 accused. But according to the charge sheet, only one Bablu Molla has been charge sheeted in the case, Lordship.
How many accused?
In the FIR, Lordship, it was supposed to be
One.
five, Lordship. But after investigation was completed, only one accused was charged in this case, Lordship. Why? Because he was holding the contraband substances. But from where did the contraband substances come, Lordship? The contraband substances came from, Lordship, this person, Lordship. It is written in the FIR also. Under the above circumstances, last page number 13, Lordship. Page number 13. I arrested the above noted accused persons on maintaining all guidelines of the Apex Court of India, as well as made him aware of for reason for being arrested. It has been revealed to put on record that on careful scanning under sliphood manner of both Android cell phones being recovered from his position, that several financial transactions as well as conversations have been made with different persons as required to be examined from the forensic expert in order to complete the circle of such and such, Lordship. It has been strongly proved that accused persons, after hatching up of criminals and with third party, Akhil, Kali, Mohammed Atur, under clandestine manner, used to involve themselves. Lordship, they are also been, Lordship, FIR name. But Lordship, kindly see the charge sheet now. Charge sheet has been submitted during investigation. Page number 20 of the application, bail application. During further investigation, it could be revealed to be put on record that the above noted accused person, namely Bablu Molla, because the contraband substances regarding 747 grams of heroin was suspected to be seized from him. That is
So you are the person from whom conscious possession of the...
But none of the others were interrogated, nor, Lordship, they were charge sheeted. My only submission is regarding that. And another point is, Lordship, kindly consider this judgment, Lordship. Delay in trial, Lordship.
Delay in trial. Page number 9 of their application. They have not placed their application on March.
Paragraph 4.
Page number 9. They have not placed their application.
at that point of time, they did not think of that there is a delay from trial.
Because at that relevant point of time, we also thought that charges will be framed, but till now, till today, Lordship, charges have not been framed. Next date is fixed on 37, 26, 26 for production of charge. Now, Lordship,
please
I
come.
am eagerly awaiting when the charge will be framed.
The petitioner is in custody for how many days you said? 500?
510 days, Lordship,
Mashallah.
as of today.
Stop. It has been submitted that there is enough delay in trial for which his prayer for bail ought to be allowed. Stop. From the documents annexed to the application for bail, it appears that the contraband and that commercial quantity of contraband substance was recovered from the conscious possession of the petitioner. Stop. The learned advocate representing the state opposes the prayer for bail. Stop. It has been submitted that the earlier application for bail filed by the petitioner was dismissed as not filed by the petitioner, being CRM within bracket NDPS 41/2026 stood dismissed as not pressed on 17th March 2026. Stop. Paragraph. Acha. What is the submission of the state? This is 72? 72.
They were facing that trial is not.
Yes, no, that is all right.
With respect to that portion, that they have not placed the application on March.
Acha. কি বললাম?
It has been submitted that the earlier application for
But
bail.
my contention regarding this particular application is Article 21.
আচ্ছা, ঠিক আছে। কি বললাম? Has been
It gives me circumstances from 17 March 2026.
ঠিক আছে। একটা প্যারাগ্রাফ দিয়ে দেখুন। On the ground of violation of Article 21 of the Constitution of India, learned advocate for the petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of লিখে নেবেন তো কেস নাম্বারটাও লিখে নেবেন live law, wherein the court considered the prolonged incarceration of the appellant and granted conditional bail. Stop paragraph. It on a perusal of the judgment order in Rabi Prakash within bracket Supra, it appears that the NDPS case was registered in the year 2019 and the appellant reached up to the Honorable Supreme Court in the year 2023. Stop. Such is not the case here. Stop. The petitioner has been found to be in possession of commercial quantity of contraband substance. Stop. The prayer for bail of the petitioner cannot be allowed at this stage. Rejected. $73 dismissed. Seven years.
This case is behind the part for the case and counter.
What is the offense?
As per FIR, petitioner go and try to But no.
Your Ladyship, for the state, the CD is not available as per.
Not
Not
available?
available.
Get the CD.
There is not.
When can you get it?
Which PS? Rajganj.
Rajganj.
Local PS, 45. Ninth.
Thursday, Your Lordship.
Thursday? List on Thursday? Stop, the CD be produced.
Report was gone for it.
Report. Yes, is the report tomorrow? See, it was adjourned on the last week also.
The Arjun Council is in report number 5.
But the report should have been here.
Report is dear Lordship.
Where is it? The report was to be filed only to ascertain the post bail conduct of the petitioner. What does the report say?
It is not clear with me right now.
Not clear
With me right now.
Oh,
The report has come, I have the knowledge of that.
then go through the report and come back. When do I keep it?
Tomorrow, Lordship.
Urgent for the day on the prayer of the APP.
Like
98, my lord, I'm for the petition.
7.
Lord, the incident is of April 24. Lord, a scuffle happened between some people.
The case diary, is it
Yes,
there?
Your Ladyship, it's available.
Lord, a scuffle happened between some people and one person suffered death. The wife, my lord, files the complaint and the FIR is registered. My lord, I am one of the accused persons. There are altogether 7 accused persons. My lord, all other accused persons who are similarly placed with me have all been granted bail. I have voluntarily surrendered before the Learned Trial Court on 2nd of March 26. Since then, my lord, I'm in custody. Today is, my lord, 123 days. In custody, my lord, I'm placing the bail orders of all the other accused persons.
What is your submission? The other co-accused are on bail?
Ladyship,
What is
but
the stage of the investigation?
The charge sheet has been submitted.
charge sheet has been submitted, Your Ladyship. But there is
Trial has also
there
come.
is this 164 statement by a witness
Yes.
that states the presence,
Involvement of the
involvement
petitioner.
of this present petitioner.
And the others are not, are their names also reflected?
Yes, Your Ladyship.
Their names are, accused names are also.
Initially, the case was registered, Your Ladyship, for 307, Your Ladyship. But in the charge sheet, 302 has been, because the victim has died, apparently expired. And the PM report states that the injury is in the
Just
skull.
check up
Skull.
whether the other accused and the petitioner are in the same footing or not. If
Ladyship.
there is any difference, let the court know. If there is no difference, then why will the principle of parity not be allowed?
But this is a heinous crime, Your Ladyship, and moreover.
True,
the
heinous crime in
name-
respect of the other accused also,
Ladyship.
right? So go through the CD and let the court know as to whether the petitioner stands in the same footing as the other.
1 year competition.
Lord, seize for once, my lord, the order dated 10th of April. Granting bail to one Subhash Chandra Roy. I have,
Subhash Chandra Roy?
yes, my lord, Subhash Chandra Roy.
Yes.
Paragraph 6. Paragraph 6, my lord.
Are
talks-
everything mentioned?
Paragraph 6 talks about the 164 statement.
Who is this another co-accused?
This is Milord, the principal accused, who is Sohail Hussain. He has also been granted. Sohail Hussain was granted bail on 18th of June 25.
Your ladyship, let this matter be listed on Friday. I'm going to call the IO.
No, please pick
and
it
I'm
up
gonna-
tomorrow, sir.
Friday, ladyship.
You don't address him, you address the court. The court is here to manage affairs.
Yes.
Right, Friday will be difficult. At best, Thursday I can keep it.
Wednesday then, my lord. Wednesday is fine.
Wednesday is tomorrow.
Yes, your ladyship. I'm going.
So, will it be
Yes.
okay?
Yes, your ladyship.
All right. Acha, the petitioner prays for bail on the ground of parity. Stop. It has been submitted that 6 out of the total 7 accused, FIR named accused, have been granted bail. 6 out of 7?
Milord, 4 out of 7. 4 out of 7.
What about the other?
Milord, 2 are absconding and 1 is a juvenile.
Acha. 4 out of 7. Stop. 2 accused are absconding. Stop. Paragraph. Learned advocate representing the state seeks time to revert with instructions. Released tomorrow.
Grateful.
Go through the bail orders passed in the other matters also.
Ladyship.
So good.
99.
Lordship, the arguing counsel is out of station due to his son's admission in college. Kindly keep it on Thursday on 9th. He will come back tomorrow evening and he will do the matter physically on Thursday.
Ready with the CD?
Yes, your ladyship.
Go through it properly. Day after tomorrow on the prayer of the petitioner.
Item number 100.
Lordship, I want to not press this application.
Not press. Yes. Has Wakalatnama been filed?
During the course of the day, I will sign.
Please record an undertaking for filing Wakalatnama in the course of the day. Not press.
Under one.
My lord. My lord, there was a affair between a boy and girl, and the families did not accept it. So there was a dispute, and out of that, there was a scuffle between the 2 families. And on that scuffle, 2 persons expired. Now, over that, FIR was lodged wherein 21 person has been named abruptly. All the neighbors who were not present at the spot, all have been named. Now, this petitioner was neither present on the spot. Nothing has been seized from them. Out of
Who are you
I am for the de facto lordship.
my lord, out of that, 10 of the accused persons who were in
De facto
custody.
has not been made a party. Did you get a copy?
Yes, they must have
Yes.
been. They have been appealed.
Yes, your lordship.
My lord, all the
De
10.
facto is not a party. It's only the state. It
My
is
lord.
only the state you check up. The de facto is not a, you don't have a copy? Where is petitioner? Where is your copy?
I've got a copy.
Check up. The de facto is not a party over here.
My lord, I didn't know that the de facto.
You have served.